Article 1159. Obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. Contractual obligations. The above article speaks of contractual obligations or obligations arising from contracts or voluntary agreements. It is a meeting of minds between two persons whereby one binds himself with respect to the other, to give something or to render some service. It is the formal expression by the parties of the rights and obligations they have agreed upon with respect to each other. 1. Binding force. Obligations arising from contracts are governed primarily by the agreement of the contracting parties. Once perfected, valid contracts have the force of law between the parties who are bound to comply therewith in good faith. In characterizing contracts as having the force of law between the parties, the law stresses the obligatory nature of a binding and valid agreement. A. The law recognizing the obligatory force of contracts will not permit a party to be set free from liability for any kind of misperformance of the contractual undertaking or a contravention of the tenor thereof. The mere proof of the existence of the contract and the failure of its compliance justify a corresponding right of relief. B. In law, whatever fairly puts a person on inquiry is sufficient notice, where the means of knowledge are at hand, which is pursued by proper inquiry. The full truth might have been ascertained. C. If it occurs to one of the contracting parties to allege some defect in a contract as a reason for invalidating it, such alleged defect must be proved by him by convincing evidence, since its validity or compliance cannot be left to will of one of them. It behoves every contracting party to learn and to know the contents of an instrument before signing and agreeing to it. D. Courts have no alternative but to enforce contracts as they were agreed upon and written when the terms thereof are clear and leave no room for interpretation. This does not mean, however, that contracts is superior to the law. Although a contract is the law between the contracting parties, the provisions of positive law which regulate such contracts are deemed included and shall limit and govern the relations between the parties. E. A compromise agreement is immediately executory and not appealable, except for vices of consent or forgery. 2. Requirements of a valid contract. As a source of obligation, a contract must be valid and enforceable. A contract is valid if it is not contrary to law, morals, good customs, public order, and public policy. 3. Where contract requires approval by the government. Where a contract is required to be verified and approved by the government before it can take effect. Example, contract for overseas employment must be approved by the Philippine Overseas Employment Administration. 4. Compliance in good faith. It means compliance or performance in accordance with the stipulations or terms of the contract or agreement. Good faith and fair dealing must be observed to prevent one party from taking unfair advantage over the other. Liability for breach of contract. Although the contract imposes no penalty for its violation, a party cannot breach it with impunity. Our law on contracts recognizes the principle that actionable injury inheres in every contractual breach. 6. Preservation of interest of promise. A breach upon the contract confers upon the injured party a valid cause for recovering that which may have been lost or suffered. Article 1160. Obligations derived from quasi-contracts shall be subject to the provisions of Chapter 1, Title 12 of this book, Quasi-Contractual Obligations. Article 1160 treats of obligations arising from quasi-contracts or contracts implied in law. What is a quasi-contract? A quasi-contract is that juridical relation resulting from certain lawful, voluntary, and unilateral acts by virtue of which the parties become bound to each other to the end that no one will be unjustly enriched or benefited at the expense of another. It is not properly a contract at all. In a contract, there is a meeting of the minds or consent. The parties must have deliberately entered into a formal agreement. In a quasi-contract, there is no consent, but the same is supplied by fiction of law. In other words, the law considers the parties as having entered into a contract irrespective of their intention to prevent injustice. Kinds of quasi-contracts. The principal kinds of quasi-contracts are negotiorum justeo and soluteo indebeti. 1. Negotiorum justeo is the voluntary management of the property or affairs of another without the knowledge or consent of the latter. This juridical relation does not arise in either of these instances. A. When the property or business is not neglected or abandoned, in which case the provisions of the Civil Code regarding unauthorized contracts shall govern, or B. If in fact the manager has been tacitly authorized by the owner, in which case the rules on agency shall govern. 2. Soluteo indebeti is the juridical relation which is created when something is received when there is no right to demand it, and it was unduly delivered through mistake. Soluteo indebeti applies where A. Payment is made when there exists no binding relation between the payer, who has no duty to pay, and the person who received the payment, and B. The payment is made through mistake and not through liberality or some other cause. Article 1161. Civil obligations arising from criminal offenses shall be governed by the penal laws, subject to the provisions of Article 2177 and of the pertinent provisions of Chapter 2. Civil liability arising from crimes or delicts. This article deals with civil liability arising from crimes or delicts. 1. The commission of an offense has a two-pronged effect, one on the public as it breaches the social order, and the other upon the private victim as it causes personal sufferings or injury, each of which is addressed, respectively, by the imposition of heavier punishment on the accused and by an award additional damages to the victim. 2. Oftentimes, the commission of a crime causes not only moral evil, but also material damage. From this principle, the rule has been established that every person criminally liable for a felony is also civilly liable. In crimes, however, which cause no material damage, there is no civil liability to be enforced, but a person not criminally responsible may still be liable civilly. Reservation of right to recover civil liability. Under the present rule, only the civil liability arising from the offense charge is deemed instituted with the criminal action unless the offended party waives the civil action, reserves his right to institute it separately, or institutes the civil action prior to the criminal action. Scope of civil liability. The extent of the civil liability arising from crimes is governed by the revised Penal Code and the Civil Code. This civil liability includes 1. Restitution, 2. Reparation for the damage caused, and 3. Indemnification for consequential damages. Article 1162. Obligations derived from quasi-delicts shall be governed by the provisions of Chapter 2. Obligations arising from quasi-delicts. The above provision treats of obligations arising from quasi-delicts or torts. What is a quasi-delict? A quasi-delict is an act or omission by a person which causes damage to another in his person, property, or rights, giving rise to an obligation to pay for the damage done, there being fault or negligence, but there is no pre-existing contractual relation between the parties. Requisites of quasi-delict. Before a person can be held liable for quasi-delict, the following requisites must be present. 1. There must be an act or omission by the defendant. 2. There must be fault or negligence of the defendant. 3. There must be damage caused to the plaintiff. 4. There must be a direct relation or connection of cause and effect between the act or omission and the damage. And 5. There is no pre-existing contractual relation between the parties. Crime distinguished from quasi-delict. The following are the distinctions. 1. In crime or delict, there is criminal or malicious intent or criminal negligence, while in quasi-delict there is only negligence. 2. Crime affects public interest, while quasi-delict concerns private interest. 3. In crime, there are generally two liabilities, criminal and civil, while in quasi-delict, there is only civil liability. 4. In crime or delict, the purpose is punishment, while in quasi-delict, indemnification of the offended party. 5. Criminal liability cannot be compromised or settled by the parties themselves, while the liability for quasi-delict can be compromised as any other civil liability. 6. In crime, the guilt of the accused must be proved beyond reasonable doubt, while in quasi-delict, the fault or negligence of the defendant need only be proved by preponderance of evidence. And 7. In crime, the liability of the person responsible for the author of the negligent act or omission is subsidiary, while in quasi-delict it is direct and primary.